Hello everyone, thank you so much for tuning in. I'm super excited to have you watching this video. In today's video, I'll be sharing with you possible objections you may raise during trial. It could be civil or criminal. These objections can always work for you either in a criminal case or in a civil case. So if you're a lawyer, you're a law student, and you're watching this video is for you. If you're a layman, you can as well watch this video to learn one or two. My name is Mary. I am a practicing lawyer in Nigeria. On this channel, I share videos for laymen and for lawyers. If this is your first time on my YouTube channel, please do well to click on the subscribe button. And if you're a returning subscriber, I do appreciate you. Thank you for always coming back to watch my videos. So without further ado, let's dive into it. The first thing I'll be mentioning in this video, the first objection you may raise during trial is on questions that is intended to annoy or to insult your witness. If you have a witness in the witness box and the other counsel is asking questions to make your clients to insult your clients or to annoy your client, questions like it is actually on record, or it is known that you're actually a renowned armed robber, like questions that would definitely that is insultive, that may make the witness to actually start answering questions, like to lose his train of thought and start answering questions that is not meant to be answered. So you can always raise an objection in court and tell the court that you're raising an objection before your witness answer the question. That is when you're meant to, immediately the question is being asked, that is when you're meant to raise that objection and give your reasons that, my lord, I am objecting to this line of question. This question is intended to actually insult or to annoy my witness. And most likely, if truly that question is in that line, the court will actually maintain your objection and allow and tell the other counsel to actually rephrase the question. So number two is leading questions. Leading questions are not allowed during examination in chief. And I believe as a lawyer, you should know what examination in chief is all about. And I think I'll be making videos on examination in chief, cross-examination, and re-examination as well. So when you talk about examination in chief, that is when you put your witness in the witness box and you are the one asking the questions. That is, you are asking your own witness questions. That's the examination in chief. So it is not allowed for you to ask leading questions. Leading questions are actually questions that suggests the answer. However, in cross-examination, leading questions are allowed. That is when you are asking the witness of the other party questions. That is cross-examination, and it is allowed for you to actually ask leading questions. Okay, so but in examination in chief, if a counsel is asking his or her own witness questions and the questions suggest the answer, you need to raise an objection and tell the court, my lord, I am objecting to that line of question. Those questions are actually leading questions. So that is number two. Number three, already answered question. It is possible for a counsel to keep repeating a question. For example, if a question has been asked, let's say the first question has been asked, and the counsel could not get the answer he or she wants, it is possible for that counsel to smartly, the fourth question should now be that same question which has been rephrased. So in that situation, that is why it is important for you to be attentive while during trial. If possible, go with someone who can record the evidence for you, while you can pay attention and write necessary questions and to raise objections as at when necessary. Okay, so when a question has been already answered, if for example, let me think of a question now. If I'm asking my witness, madam, on the 21st January 2022, were you at home? Were you in your house? The first, okay, if the witness say yes, I was at home, or no, I wasn't at home, and later he's trying to ask, on the 21st January 2022, were you in Abuja? And probably the person have answered earlier that I wasn't at home. I was in the UK. Sometimes lawyers do it to smartly make confuse the witness, for the witness actually give answers that will suit them, that will suit their whole line of argument. Okay, so number four is hearsay questions. Hearsay is actually when you're reporting something that's a fact that you heard from someone. For example, if I'm in the witness box and I'm telling the court that I was told by the plaintiff that the defendant is owing him some sum of money, that is hearsay. Though there are exemptions to it that hearsay will be allowed in courts, but as a general rule, hearsay are not admissible. Okay, For me, I'd love to actually wait till cross examination to ask those questions, or in final written address. So it all depends on lawyers. Some people love to actually raise it as an objection. Some people love to raise it during cross examination and final written address. For me, I love to raise it during cross examination and final written address. It all depends on, there is a way that everyone just love to do their thing, and they feel it to actually give them what they want. So if you want to raise it during prior, when the witness is being asked, you can as well raise it. It all depends if the judge will sustain your objection. So that is that about yes, yeah, that's the fourth. The fifth is opinion questions. Opinion questions are not admissible. For example, if someone is in a witness box, I am a lawyer, and someone is asking me questions relating to, do you know how autopsy is being done? And do you know this about autopsy? The counsel, my own lawyer, can say, my lord, I'm objecting to that question because that is an opinion question. And my opinion, it will not be relevant because I'm not an expert in that field. So that is that about opinion questions. Six are irrelevant questions. And you know this thing about relevancy and admissibility when it comes to evidence in Nigeria. So if questions are being asked that are not relevant to the subject matter, that is to the subject matter, to the cause of action in court, there is no need for those questions to be asked. Always raise objection to that. And this saying that the sky is the limit in cross-examination, in my own opinion, it is wrong. And I think there are a lot of people that are also of the opinion that that particular statement is actually wrong, to say the sky is the limit in cross-examination. I wouldn't come to court for a dispute over land and you are asking questions on all aspects, saying the sky is your limit. That would be wrong. That would be, except if there are other explanations to that statement. But to ask every question, it should be based on the subject matter. So if you're in court and you notice that the other counsel is asking questions that are not within the subject matter, you can always raise objection that that line of question, will you be objecting to it on the basis that it is an irrelevant question to the subject matter. So that is number six. So for other objections, I'll be talking about the objections you may raise as to documents that are being sought to be tendered. Number one is when it's a computer generated evidence. Section 84 of the 1999 of the Evidence Act of 2011. Yeah, 2011. So you can always raise objection if there is no certificate of compliance. However, there is a provision, there is a principle by the Court of Appeal that if a document has been printed, is computer generated, and there is no certificate of compliance, if the maker of the document, that is the one who printed the document, is in court, that was can actually give evidence towards it. So it is not in all instances that you must be with a certificate of compliance. I will try and supply the citation of that particular case. So if it happens that you're in court and you did not prepare yourself for that, I will still make, I think I'll make an elaborate video on computer generated evidence, and I'll also include that authority. So that is that. Another thing is an undated or a document that is not signed. So you can always reach objection to that. For a document to be, how can I put it now, to be admissible, it can be relevant. Let's say dispute over land and you want to actually tender a certificate of occupancy. It is relevant to the subject matter. But what about the admissibility? Is it dated? Is it signed? So you need to check all of those things. If it's an undated document, I am sure that the court will definitely oblige your objection on that document. Okay, so it is important for the document to be dated. So once the document is being given to you, like, okay, I applied to tender the document and the document is being brought to you, check, is it dated, is it signed, and check all the things. Thank God for front loading, like we front load documents, so you can always do all of that even with the assistance of a senior colleague before you go to court, to check reasonable objections that you may raise to those documents. Because once the document is being admitted, it's definitely helped their case. So you need to look for lacuna, look for the loopholes that you can use to actually destroy or discredit such evidence, such documents. So the next thing is, when a witness is not the maker of a document, it is necessary that when you want to tender a document, it should be, the witness should be the maker of that document. Like if I have a certificate of occupancy that belongs to me, that's been issued by the governor of the states where the land is, situated, and I'm using, let's say, my secretary, probably who witnessed when I paid for the land as a witness to tender that document. She's not the maker. I would have been the best person to actually be in the witness box to say, okay, that is my certificate of occupancy. You can always raise that objection, okay? So another thing is when a document is not a certified true copy. So if it's a public document and for example, what's best example can I use now? Nothing is coming to mind. Basically, if there is a public document and a council is about to tender that document, it is necessary for you to check, is it a certified true copy? So it is necessary for a public document to be certified. If you're making a document from any, let's say, federal government agency and all of that, you should apply for a certified true copy, so that way it soon that way you'll be able to tell the court that you have not gone to actually forge a document once it's been stamped CTC and it's been signed. So another thing is a secondary evidence. We everything that is admissible in court is actually primary evidence, that is the original. So if you're coming to court with photocopies, probably you have the originals, but you want to keep the originals, or you can't find the originals, or the originals are in the custody of the other party. So you need to lay evidence to that in that regard. So always raise objection that these are secondary evidence, and there has been no foundation as to the primary, the source, the other source of the document, I think the primary one. So definitely the court will oblige that objection. Okay, so that is that for secondary evidence. And yeah, I think I've been able to cover all the 11 points, 11 objections I actually raised in this in my notes. So I hope this video educates you. If you have further questions, please do not hesitate to drop in the comment section. I'll be willing and I'll be happy to hear from you. Thank you so much, and I will see you in another video.